And for one final time tonight, it is my high honor to present to you the 2023 Thurgood Marshall honoree, John Echohawk.
Thank you. Thank you. Thank you. Well, I'm very honored to receive this award and be introduced by Kristen Clark and Mary Smith and my friend Judge Hartz. Once again, I want to thank the ABA for this very high honor. It's something that I will revere for the rest of my life. I want to say that it's really not only for me, but for the organization that I've been with for 53 years, the Native American Rights Fund. And we've got board and staff members sitting over here in these tables, and they're doing great work that help our people all across the country, and they really represent all the board and staff members who have been with this organization over 53 years that have done all of this great work. And they're able to do that because they are, like me, they're just very dedicated to protecting the rights of Native Americans, and they do a wonderful job at that, so thank you, thank you. We could not have done that without the great support of all of our donors. It's a nonprofit organization. We depend on these donors to help us continue the work that we're doing, and we really appreciate their support, and also the support of our courageous clients, our tribes and Native organizations, individuals who are under great pressure when they bring their case to us and having their rights suppressed, and they stand solid to make sure that they do what they need to do as our clients to make our work much easier. So we just really appreciate the courage of all of our clients over all of those years. We've represented most of the tribes in this country over the years, dozens and dozens and dozens of Native organizations and individuals across the country. I also want to acknowledge the president of my family here. I could not have really done this without them, as has been talked about a little bit by Judge Hartz. I come really from a great family there, being raised in Farmington, New Mexico with my brothers and sisters there, and a great mom and dad. They didn't have college educations themselves, but they knew that their kids were going to be college educated, and they made us study, and if you didn't study, you got in big trouble. So we all studied, and I studied, and we all did well, and we've all got college degrees, graduate degrees. We all paid attention to our mom and dad. We just owe them a great amount of debt for all of the leadership that they gave their kids in terms of getting ready for a better life. I had wanted to be a lawyer based on the experience I had there at Farmington High School, like Judge Hartz was talking about. I was encouraged by many of my teachers to think about law. I kind of figured I could do whatever I needed to do, and I decided, well, okay, I'll just be a lawyer. And so when I got out of graduate school at the University of Mexico, putting in 4 years, it was just pre-law training, that's all it was. And so, I got my degree in government and economics, and was all set to go to law school, and went over to the University of New Mexico Law School to make sure they got my application and to check on their scholarships. I had a scholarship for undergraduate school, and needed one to go to law school, and I was just at the right place at the right time. I walk in, and the receptionist says, "You look like an Indian." And, yeah, well, do you have time to talk to the dean? And I said, "Well, I'm not even admitted, and I'm already in trouble." And so I went back and saw the dean, and remarkably, the dean of the law school told me about a program that the UNM Law School had just signed up to run, and that was a program that had been given to them by the Office of Economic Opportunity in Washington, D.C. as part of the war on poverty. And the powers that be back there figured one of the best things they could do to help American Indians get out of poverty is to finally get some professionals. We had virtually no lawyers, no doctors, and it had only been a few years where the federal government had been giving out scholarships for Indians to go to college, because before that, they thought all we could do was just vocational schools. And so we were starting to go through college, and they thought, hey, maybe these Indians could go to graduate school. Maybe they could get graduate degrees and become lawyers and doctors. So they asked UNM to run this program across the country, handing out scholarships to Indians to go to law school. And so I got a scholarship, and away we went. It was also a feature of that program when it started to have a summer law session, a boot camp, if you will, for us Native American students who wanted to go to law school, and they wanted to give us a few weeks of training to tell us what law school was going to be like and to try to get us ready for September. So we went through that first, what they call now the Pre-Law Summer Institute, which is still going down at the University of New Mexico Law School. And many of the Native American lawyers that are here remember going through that PLSI program. That was a really good program. Got us ready for law school. To the credit of that law school, they put together one of the first courses ever taught in a law school about federal Indian law. And they exposed us to that in this Pre-Law Summer Institute, and then during the regular school year with an Indian law course. And I took the course together with the other Native students who started there at UNM. Some of the other students went to other law schools across the West. But it was my first exposure to federal Indian law, and the first exposure of most of my fellow Native American students to federal Indian law. And basically, we discovered that tribes and our Native American people had substantial rights under law that we didn't really know much about, and we didn't think our tribal leaders knew much about either. And why? Because we were the poorest of the poor. We didn't have any lawyers. And in addition to that, the policy of the federal government there in the late 60s was still one of termination of our tribes and forcing assimilation of our people. And they were not available to carry out their responsibilities to help us enforce the treaties and laws that protected ourselves. And we were just really learning all about that. We drew great inspiration from what was happening there in the late 60s that we've talked about here at this meeting here this evening. And that was the civil rights movement that was going on. And we kind of learned how that worked. The African American people were having their right to be free of discrimination and to have civil rights, equal rights with everyone else. Even though they were poor, they had lawyers. And they got these lawyers from the NAACP Legal Defense Fund that we talked about, that Thurgood Marshall, of course, started, and saw that they were basically raising money and hiring lawyers and making them available to represent African Americans in the important cases. And we thought, hey, that's something that we ought to do as well. That notion was fortified by another program that the Office of Economic Opportunity had started there in the 60s, and that was for the first time in U.S. history providing funding for legal aid offices across the country to represent poor people. And that was really a first. Before that, all they depended on was just volunteer lawyers, and even though we had a few, didn't really have all that many, and we really needed this legal services program. The legal services program put out some of these grants to Native organizations on reservations. There were 7 of them started. And again, to the credit of the professors there at the UNM Law School, they were in touch with these Indian legal services programs and watching the cases that they were bringing on behalf of Native Americans, brought by all these young lawyers they had out there in legal services from Harvard and Yale and things. And of course, they never had any federal Indian law, but of course they researched and they found it. And they started enforcing federal Indian law on these reservations and these legal services programs. And we learned about that in law school and saw the success they were having. One of these notions that came to mind was how we could start one of those. And once again, I was at the right place at the right time. When I graduated from law school, I went to work for one of these Indian legal services organizations, the California Indian Legal Services. And as soon as I got out there, they told me that they had been up to New York City talking with the Ford Foundation that had funded the NAACP Legal Defense Fund, that had started funding the new Mexican-American Legal Defense Fund, and they wanted to know whether CILS wanted to start a Native American Legal Defense Fund nationally. And CILS said yes, and so as soon as I got out there and started to work at CILS, they came and asked me, do you want to help work on this new project to start a National Indian Legal Defense Fund? And again, right place at the right time. I said, sure. That was my dream come true right there. Wow, okay. So away we went. We spent a year getting started there in California, and then relocated a year later, incorporating separately with our main office in Boulder, Colorado, with an association with the University of Colorado Law School. One of our grants had to go through a law school, and CU Law School was very interested in working with us, so away we went. We grew fairly quickly, and we had a lot of requests for assistance on all of these important issues. We had the guidance of a Native American board of directors that helped us set the priorities for the organization. Of course, there's no way we could represent everybody who was asking us for assistance, so they set out the priorities, protecting tribal sovereignty, protecting our natural resources, our human rights, our rights to our religions and culture, the enforcement of the trust responsibility of the federal government, and the development of Indian law and educating the public about Indian law and policy, because really nobody knew anything about that. So those were the priorities that were set, and we started. We took on a big treaty rights case right off the U.S. v. Washington case involving the tribes in western Washington and their rights under the treaties to fish the way they always had. They always depended on the salmon there, and they had a treaty provision that allowed them to continue to fish at their usual and accustomed places in common with the citizens of the state. This language had been interpreted by the state of Washington to mean you got to get a fishing license just like everybody else. But of course, that's not the way the tribes had understood that, and that's the argument that we brought forward in the court. The tribes, of course, started out with all the fish and agreed to share half the fish with the state of Washington, and that was what that treaty provision meant. So the tribes went from getting 2% of the fish to 50% of the fish, co-managing with the state of Washington. And that was a treaty right, and everybody took note of the fact that these treaties were not ancient history. They were the supreme law of the land, and other treaty cases followed that we worked on, and other folks worked on as well. We had also undertaken a representation of the Menominee Nation in Wisconsin. This was one of the tribes that had gotten terminated by the federal government during that termination era, and of course, when that happened in the 50s, Congress says, oh, this is going to be good for all you people. We're going to do away with the reservation, send you to the city, and and you're going to be great. You're going to do very well. And of course, that didn't happen that way. They were the poorest of the poor, and so they came to us and asked for our help, and we helped them in D.C., and they basically went up and told their story. This didn't work, and we want to have our tribe restored. And the Congress said, oh, sorry, okay. And so they got restored, and other tribes followed in their footsteps because the other terminated tribes had the same experience. And so that was a great victory as well. Another one of the early cases we undertook was for the tribes in Maine, the Passamaquoddy and Penobscot. They came to us and knocked on our door and told us who they were, and we looked at the map of the Bureau of Indian Affairs with all the reservations and things, and there are no tribes in the east. Who are you guys? You're not tribes. And, yeah, we are. And so they showed us all our history and everything, and they had all these relationships early on with the U.S. government, but the state of Maine just kind of took over and took their land and everything, and the feds never did anything. And there was, of course, the 1790 Non-Intercourse Act that basically said no transactions with tribes unless they are approved by the federal government through treaty. So we took that law to court, and the court says, yeah, this was the law, and so the state of Maine has to give back all this land they took from the tribes, about 2/3 of the state of Maine. Of course, the state appealed, and the Court of Appeals affirmed, said, yeah, you got to give that land back. It's not your land. It's illegal. And so we were all headed for the Supreme Court before President Carter calls and says, time out. Why don't you folks come to the White House and let's talk this over, because somebody's going to be a big winner and somebody's going to be a big loser, and you might want to talk about settling. So we all went and we talked, and ended up with a huge settlement for those tribes. They got a lot of their land back, a lot of money, and federal recognition. And there were several other eastern tribes that came after that went through the same thing with their original 13 states. And so we had a lot of land claims and land returns and federal recognition for a lot of those eastern tribes and put them on the map. And those are just kind of 3 examples of some of the early work that we did. With all this going on, there was, of course, a lot of attention given to the Native American Rights Fund, and one of the things that they paid attention to was the fact that we were started with an executive director, David Getches, who's a non-Indian, and his wife Ann is here, and David did a great job starting our organization, was really a great mentor for me, but there was just so much pressure on all of us to have a Native American executive director, and I was the first Native American lawyer in the door and had the most experience, so guess who they started looking at to be the executive director? Now, I like to do the casework. I don't want to do management and fundraising and all this other stuff. Somebody's got to do it, and particularly the board. You got to step up and do this. Okay, so I stepped up. So here it is, 53 years later, and still going. Along the way, I tried to get other Native American lawyers to do this. They said, no, you got to do this. And I couldn't get out of it, so I'm still here. We were really instrumental in the development of federal Indian law and improving the social and economic and political conditions of tribes. As they got on their feet, this whole field of Indian law developed, and we started getting firms with Indian law practices, and tribes could finally pay some of these firms, and boy, anymore, Indian law is really big across the board. We still get a lot of business there at the Native American Rights Fund, though, because there's still a lot of tribes, organizations, individuals that need legal representation, and these issues never stop. As was referenced earlier in the talks, the U.S. Supreme Court took an inordinate number of these Indian law cases beginning in the 70s and 80s when we came along, and of course we were instrumental in a lot of those, and for the most part we won those cases, and it really changed everything and drove this whole tribal sovereignty movement. Things started changing a bit later, but the 70s and 80s were really good. We had the support of Justice Thurgood Marshall during that time. He was on the court from 67 to 91. He wrote more favorable Indian law opinions than any other justice, so he was a great friend of ours, and he understood these civil rights issues for Native Americans, and he was really a great hero of mine. We have continued our work on all these big issues. More often than not, we file amicus curiae briefs for tribes in support of the tribe that actually has a case before the Supreme Court, and perhaps the most famous case that people always ask about is the case that had to do with tribes getting into gaming and having the right to to open casinos and things, and this was a case that the Supreme Court decided in favor of the tribes in 1987 because, of course, tribes are sovereign governments, and just like states, they can do gaming too if they want, and that's what the Supreme Court ruled, and of course that really changed everything, and these days the biggest economic driver in Indian country is gaming, and that was a tremendous victory for tribal sovereignty for tribes. All these issues continue today, even though we don't have as favorable a court as we used to have. We're still able to win now and then. We've already talked about one of those big victories, the Brackeen against Holland case, the Indian Child Welfare Act case, just this last term. We were really kind of concerned that with this court the way it is, maybe they're going to say that Congress did not have authority to pass that Indian Child Welfare Act in 1978, and if they said that was somehow discrimination against white people, then we would all be in big trouble in terms of trying to figure out what other laws Congress passed about tribes and Indians that would also be declared unconstitutional. So it was just a great relief for all of us to have won that case with the ruling 7-2. Again, we played an instrumental part in that case, filing the big amicus brief for the tribes and in support of the tribes that were actually involved in the case. We had 497 of our 574 tribes sign on to that amicus brief. That's the most tribes we've ever had sign on to an amicus curiae brief, and I'm sure the court took notice of that. So issues like that continue. We have our tribal Supreme Court project that the tribal leaders ask us to work on with the National Congress of American Indians, and we monitor all these cases that are headed for the Supreme Court and offer our assistance whatever way we can, and are just hopeful that under the leadership of Justice Gorsuch that the Supreme Court's going to learn more about federal Indian law and be ruling in our favor when these cases do get up to them. So our work continues. This, again, is work that this organization leads. It's really good to have so many Native representatives here in this room, because we work with all of you on all of these issues, and that's the strength that we have staying together, and hopefully we'll be able to continue to protect the sovereign existence of tribes in this country. So once again, thank you for this honor, and thank you for coming this evening.